There is a 67-year-old woman in Phoenix, Arizona. She paid her rent on time for 11 straight years, never missed a single payment, never caused a single problem, and one morning she woke up to a notice taped on her front door telling her the building had been sold and she had 30 days to pack everything she owned and leave. What nobody told her, and what her landlord was certainly never going to tell her, is that one free document, one single page filed with her city's housing office, would have legally forced that landlord to give her 90 extra days and potentially pay her moving costs out of his own pocket. That document existed the entire time. Her county had it on their website. It cost nothing. It took 20 minutes. And she never knew it was there. If you are over 60 and renting in America right now, that woman's story is not a worst-case scenario. It is Tuesday. Here is something nobody in the rental industry wants you to think about too hard. When people talk about protecting assets in retirement, they almost always talk about homeowners, the paid-off house, the equity, the deed. And look, that conversation matters, but it completely ignores an entire population of older Americans who are just as vulnerable, maybe even more vulnerable, and who nobody's talking about. Renters, specifically, renters over 60. And the first thing I need to address is the assumption that stops most renters from even looking into their own protections. That assumption is this: I don't own anything, so there's nothing to protect. I hear this all the time, and I understand why people think that way. You don't have a deed, you don't have equity, you don't have a mortgage statement showing you've built something over 30 years. So the brain just files the whole conversation under not applicable to me and moves on. That is one of the most expensive mental mistakes a renter over 60 can make. Because you do have assets. They just don't look like a house. Your lease agreement is an asset. Think about what that document actually represents. It is a legally binding contract that gives you the right to occupy a specific property at a specific price for a specific period of time. That right has real dollar value, especially if you have been in the same place for several years and your rent is below the current market rate. If your landlord can push you out, legally or otherwise, and re-rent that unit at $200 more per month, that is money coming directly out of your stability and going straight into his pocket. Your lease and your knowledge of what protections surround it is the only thing standing between you and that outcome. Your security deposit is an asset, and this one genuinely shocks people when they do the math. The national average security deposit is somewhere between 1 and 2 months of rent. For a renter paying $1,400 a month, that is potentially $2,800 sitting in an account somewhere with your name on it. Now here's the uncomfortable part. Studies on rental housing consistently show that landlords withhold deposits far more frequently from older renters and renters who don't know the specific filing requirements for getting that money back. It is not always malicious. Sometimes it is just paperwork. But the end result is the same. You lose money that was legally yours because you didn't know which document to file and when to file it. That is not a landlord problem. That is an information problem, and information problems are fixable. Your fixed income benefits are an asset. This one requires a little more explanation because it connects to something most renters over 60 don't realize is even possible. If you receive Social Security, SSI, a pension, or any form of fixed government benefit, and a creditor obtains a legal judgment against you, from a medical bill, a personal loan, a credit card, anything, they can attempt to garnish those benefits or attach a lien to your personal property. Now, federal law does protect Social Security from most garnishments, but the protections are not automatic in every situation, and they are not unlimited, and they absolutely require you to know what paperwork establishes your protected status before a judgment ever gets filed. Renters over 60 on fixed incomes are disproportionately targeted by collection agencies precisely because collection agencies know that older people on fixed incomes often have limited options and limited knowledge of their legal protections. They are counting on you not knowing. That is their entire business model. And then there is personal liability exposure, which is the asset protection issue that almost nobody talks about when they're discussing renters. If someone slips and falls in your apartment, if your dog bites a neighbor, if there is an incident of any kind that results in a lawsuit, you as a renter are personally liable for damages above whatever your renter's insurance covers. And here is what makes this specifically dangerous for renters over 60. If a judgment is entered against you, that judgment can follow you, attach to any real property you own or acquire, impact your ability to rent in the future, and in some states affect the inheritance your family receives. One lawsuit, one bad afternoon. And suddenly there is a legal cloud over everything you have spent decades building because you didn't know about 2 pages of documentation that could have limited your exposure. So let's stop using the word renter as a synonym for has nothing to lose. That framing is wrong and it is dangerous. What renters over 60 actually have is a different set of assets than homeowners, assets that require a different set of documents to protect, documents that are just as real, just as important, and just as ignored by the system that was supposed to tell you about them. Now here is the part that should genuinely bother you, and I want you to sit with this for a second. Landlords know about these protections. Property management companies have attorneys on retainer who know every filing deadline, every loophole, every technicality in your state's landlord-tenant law. They know exactly what you are entitled to, and they know exactly how to structure situations so that you never think to claim it. That is not paranoia. That is just an honest description of how an information imbalance works in a business relationship. They have the information, you don't. And the gap between those two positions is where renters over 60 lose money, lose housing stability, and lose legal standing every single day in this country. There are three groups that can come after what you have as a renter. First, landlords and property management companies who understand tenant law better than you do and use that knowledge to minimize what they owe you and maximize their ability to remove you when it becomes financially convenient for them. Second, scammers, and yes, rental scammers specifically target older renters because older renters are statistically less likely to have someone in their corner who knows the rules. Rental scams cost Americans billions of dollars every year. Older adults account for a disproportionate share of those losses. Third, creditors and collection agencies who target fixed-income renters because they know the legal process is confusing, the paperwork is overwhelming, and a significant percentage of people will simply not respond in time, even when they have every legal right to fight back. 5 documents protect you from all 3 of these groups. Most of them are free. Most of them take less than an hour to file. And the difference between having them and not having them is the difference between keeping your housing stable and watching 11 years of on-time payments count for absolutely nothing on the morning a new landlord decides your unit is worth more empty than it is with you in it. So let's talk about what those 5 documents actually are. Let me ask you something, and I want you to actually think about this for a second. When you signed your lease, did anyone hand you a list of your legal rights as a tenant? Did your landlord sit down across the table from you and say, "Hey, by the way, here are the free programs your city offers that protect you from wrongful eviction. Here is how to apply for a rent freeze if you qualify, and here is the document you need to file if we ever have a dispute about your deposit"? Did that conversation happen? Of course it didn't. And here is the thing. It was never going to happen. Because the people who are supposed to tell you about these protections are often the exact same people who benefit financially from you not knowing they exist. That is not a conspiracy theory. That is just a straightforward description of how incentives work. Your landlord is not your advocate. Your property management company is not your advocate. And your local government, as well-meaning as some of those offices genuinely are, is chronically underfunded, understaffed, and not exactly running aggressive public awareness campaigns about the free programs sitting on page 47 of their housing department website. So the information gap is not an accident. It is a structural feature of the system. And the people who fall through that gap most consistently are renters over 60, people who signed their leases before the internet made everything searchable, people who trust that if something important existed, someone official would have mentioned it by now, and people who, frankly, have more pressing things to worry about on a fixed income than researching municipal housing codes. I get it. But that trust is being exploited, and today I am going to close that gap, at least for you, starting right now. Let's talk about the first document most renters over 60 have never heard of, the Habitability Declaration. Now, the name sounds more complicated than it actually is, so let me break it down in plain language. Every state in America has something called an implied warranty of habitability. What that means in plain English is that your landlord is legally required to provide you with a livable space, heat in the winter, working plumbing, no mold that is actively making you sick, structural safety, functional locks on the doors and windows. These are not optional extras, they are legal requirements. Your landlord does not get to decide whether or not your apartment meets basic livability standards. The law decides. And if your unit falls below those standards, you have legal remedies available to you that most renters over 60 have absolutely no idea exist. Here's where the document comes in. In most states, if you want to formally assert your habitability rights, meaning if you want to put your landlord on legal notice that something in your unit is not meeting the required standard, you need to do it in writing. A verbal complaint to your landlord does almost nothing legally. I know that feels backwards. I know you are thinking, but I told him 3 times about the heating problem. Telling him is not the same as filing. A written habitability notice submitted through the proper channel in your state starts a legal clock. It gives your landlord a specific window of time to fix the problem. It creates a paper trail. And in many states, if the landlord fails to make the repair within that window, you gain the legal right to withhold a portion of your rent, hire someone to fix the problem yourself, and deduct the cost from rent, or in serious cases, break your lease without penalty. That last one is big. Breaking a lease without a habitability filing on record can cost you thousands of dollars in penalties. Breaking a lease with a properly filed habitability notice can cost you absolutely nothing. Same situation, completely different outcome. One piece of paper is the entire difference. Now let's talk about rent freeze applications, because this is the one that makes people's jaws drop when they find out it exists and they have been eligible for years without knowing. Many cities and counties across the United States offer rent stabilization or rent freeze programs specifically for low to moderate income seniors. These programs cap how much your landlord can raise your rent each year, sometimes freezing it entirely at your current rate for as long as you remain eligible and enrolled. Cities like Los Angeles, New York, San Francisco, Washington, D.C., and dozens of smaller municipalities have versions of these programs. Some states have expanded them significantly in the last 2 years as rental costs have skyrocketed, and the income thresholds are often more generous than people assume. You do not have to be in poverty to qualify, you just have to meet the criteria, which in many programs means being over a certain age and earning below a certain income level that a significant portion of fixed income retirees fall comfortably within. Here is what makes this genuinely painful to talk about. These programs exist, they are funded, they have spots available, and they are dramatically underutilized by the people they were specifically designed to help, because those people do not know the programs exist, do not know they qualify, or assume the application process is so complicated that it is not worth trying. I've seen rent freeze applications that are literally 2 pages long. 2 pages. And people are paying hundreds of dollars more per year in rent increases that they were legally protected from simply because nobody pointed them at the right form. That is money leaving your fixed income every single month for a problem that a Tuesday afternoon and a postage stamp could have solved. Then there are benefit assignment documents, and this is the protection that almost never comes up in any conversation about renter rights, but that I think is one of the most important ones for people over 60 specifically. Here's the situation this document addresses. If you receive Social Security, a pension, disability benefits, or any other form of regular government payment, and you fall behind on rent, some states allow you to voluntarily assign a portion of an incoming benefit payment directly to your landlord as part of a formal repayment arrangement. This sounds simple, but the legal implications are significant. When this assignment is properly documented, it creates a structured agreement that in many cases protects you from eviction proceedings while the repayment plan is in effect. It puts both parties on legal record as having agreed to a resolution, and it prevents the situation from escalating into a court filing that goes on your rental history and follows you to every application you make for the next 7 years. Without the document, you have a verbal agreement with your landlord that is worth exactly nothing if he decides on a Wednesday morning that he would rather file for eviction than wait for your check. With the document, you have a legally recorded arrangement that gives you breathing room, protects your rental history, and keeps you in your home while you get current. The difference is not money. It is paperwork. It is always paperwork. And here is the one that connects everything together, and that I think is the most underused resource for renters over 60 in the entire country. The tenant rights filing through your local area agency on aging. I know that name sounds like something you would find in a government brochure from 1987, and honestly, the branding has not improved much since then. But what these agencies actually do is remarkable. Every county in the United States has one. They are federally funded, their services are free, and many of them have housing advocates on staff whose entire job is to help renters over 60 understand, file, and enforce exactly the kinds of documents we are talking about today. They can review your lease, they can help you file a habitability notice, they can connect you with rent assistance programs and freeze applications you did not know existed. They can tell you the specific deadlines in your state for deposit recovery filings. And they can do all of it at no cost to you, because that is literally what they are there for. But here's the number I want you to sit with. The National Association of Area Agencies on Aging estimates that a significant majority of older adults who are eligible for housing assistance services have never contacted their local agency. Not once, not for any reason. And the number one reason given when people are surveyed is always the same. They did not know the agency existed or did not think it applied to them. That answer is the entire problem in one sentence. The resource exists, the eligibility exists, the need exists. The only thing missing is the awareness. And that awareness gap is not an accident. It is maintained, intentionally or not, by a system that has never prioritized getting this information to the people who need it most. So when I tell you that most renters don't know these documents exist, I am not saying that to be dramatic. I am saying it because it is statistically true, structurally predictable, and completely fixable the moment you decide to spend one afternoon on it. which is exactly what the rest of this conversation is going to help you do. All right, this is the part you actually came here for, and I want to be honest with you before we dive in. I am going to give you 5 specific documents. I am going to explain exactly what each one does, why it matters for renters over 60 specifically, and what happens when you don't have it. Some of these are free, some cost a small amount. None of them require a law degree. None of them require you to be wealthy or well-connected, or to have a nephew who happens to be an attorney. They require an afternoon, a printer in some cases, and the decision to treat your housing stability as seriously as it deserves to be treated. And before anyone in the comments says, well, it depends on your state, yes, of course it does. Every state has its own version of these protections. The names are sometimes different. The deadlines are sometimes different. The filing offices are sometimes different. But the underlying documents and the protections they provide exist in some form in virtually every state in this country. Your job after watching this is to go find the specific version that applies to where you live. I am going to tell you exactly what to search for. Now let's get into it. Document number 1, the written habitability notice. This is the document that most renters over 60 need, and almost none of them have ever filed. And I want to start here because this is the one that protects you right now in your current living situation, before anything else goes wrong. Here's the reality of renting over 60. You have probably been in your unit long enough that things have started to break down. The heating system that was fine 6 years ago is now unreliable in January. The bathroom ventilation that the landlord promised to fix is still not fixed. The front door lock that you reported in writing. Wait, you didn't report it in writing? That is exactly the problem, because every single time you call your landlord about a maintenance issue and he says, I'll get someone out there, and then nothing happens, and you call again and he says the same thing, and this goes on for 4 months, you are building absolutely zero legal record. You are just a person who called. And if that heating system fails completely in February and you have to spend 3 nights in a hotel, you have no documentation to support a claim for reimbursement, nothing, because you never filed the document that would have started the legal clock. A written habitability notice changes everything. It is a formal document submitted to your landlord in writing that states specifically which condition in your unit fails to meet the legal habitability standard when you first became aware of it, what verbal communications you have already had about it, and what resolution you are requesting. In most states, this document needs to be sent via certified mail with return receipt so you have proof it was received. That is important. The postmark and the signature on that return receipt are your legal record that the landlord was formally notified on a specific date. From that date, the clock starts. Most states give landlords between 14 and 30 days to make repairs on non-emergency issues. Emergency issues like no heat in winter or a sewage backup can require response within 24 to 72 hours depending on your state. What happens when the landlord ignores it? Now you have legal standing to pursue remedies. That framing is wrong and it is dangerous. What renters over 60 actually have is a different set of assets than homeowners, assets that require a different set of documents to protect, documents that are just as real, just as important, and just as ignored by the system that was supposed to tell you about them. Now here is the part that should genuinely bother you, and I want you to sit with this for a second. Landlords know about these protections. Property management companies have attorneys on retainer who know every filing deadline, every loophole, every technicality in your state's landlord-tenant law. They know exactly what you are entitled to, and they know exactly how to structure situations so that you never think to claim it. That is not paranoia. That is just an honest description of how an information imbalance works in a business relationship. They have the information, you don't. And the gap between those two positions is where renters over 60 lose money, lose housing stability, and lose legal standing every single day in this country. There are 3 groups that can come after what you have as a renter. First, landlords and property management companies who understand tenant law better than you do and use that knowledge to minimize what they owe you and maximize their ability to remove you when it becomes financially convenient for them. Second, scammers, and yes, rental scammers specifically target older renters because older renters are statistically less likely to have someone in their corner who knows the rules. Rental scams cost Americans billions of dollars every year. Older adults account for a disproportionate share of those losses. And renters over 60 are among the least likely demographic to successfully recover those funds, not because they damage the property more, but because they are the least likely to know the specific procedural steps their state requires for deposit recovery. Here is how security deposit theft actually works. And I'm going to call it theft because in many cases that is legally what it is, even if it never gets prosecuted that way. You move out. You cleaned everything, you patched the nail holes, you took photos, you were a good tenant for 9 years, and 45 days later you receive a letter claiming $1,800 in damages for things you are absolutely certain were either pre-existing conditions or normal wear and tear. And because you did not know the specific process your state requires for challenging that claim, including the deadlines, the documentation format, and the filing office, you either give up or you accept a partial return that is less than you deserve. And the landlord keeps money that was legally yours because the procedural barrier was just high enough that you decided it wasn't worth the fight. Here is what the security deposit protection filing actually does. In most states, tenants have the right to request a move-out inspection before they vacate, conducted jointly with the landlord, during which any claimed damages must be identified and documented in writing. That joint inspection report is a legal document. When you have it, any damages the landlord later claims that were not on that report are extremely difficult for him to legally justify withholding your deposit for. Additionally, most states require landlords to return your deposit within a specific window, usually 14 to 30 days after you vacate, along with an itemized written statement of any deductions. If they miss that deadline, many states automatically forfeit the landlord's right to make any deductions at all. Some states allow you to sue for double or triple the wrongfully withheld amount as a penalty. But here's the catch, and there is always a catch with these things. You have to know the deadline to challenge. Most states give tenants somewhere between 30 and 60 days after receiving the landlord's itemization to formally dispute it in small claims court. Miss that window and your claim is gone. Completely gone. You can be 100% right about every single thing and it does not matter because you filed one day late. Renters over 60 miss these windows constantly because nobody told them the window existed in the first place. I once heard about a man, lovely guy, retired postal worker in Ohio, got $400 withheld from his deposit for carpet replacement on carpet that was already 8 years old when he moved in. He had the photos, he had the receipts, he had everything. He missed the dispute filing deadline by 11 days because he did not know it existed. 11 days, $400, gone. That is what not knowing the document costs. Go to your state's tenant rights website and search Security Deposit Dispute Process. Write down the deadline. Write it in your calendar. Write it on a sticky note on your refrigerator if you have to. The document is only powerful if you file it on time. Document number 3, the wrongful eviction response filing. This is the one that protects you when a landlord decides he wants you out and starts using the process itself as a weapon against you. And I need to explain how this works because it is more common than most people realize, especially for long-term renters over 60 who are paying below market rent in a unit that a landlord could get significantly more money for if he could just get them out. Here's the playbook some landlords use. They serve you with an eviction notice for a technical violation. Maybe you had a guest stay for 3 weeks and the lease says guests are limited to 2. Maybe you got a dog and the lease technically says no pets, even though the landlord verbally told you it was fine 2 years ago. Maybe it is something even more minor than that. The violation is real enough that they can put it on paper, but the actual motivation is that they want your unit back so they can renovate it and charge the next tenant $300 more per month. The technical eviction notice is just the mechanism. Now here is what most renters over 60 do when they receive an eviction notice. They panic. And I understand that completely. An eviction notice is terrifying, especially when you are on a fixed income, and the idea of finding a new place, paying a new deposit, and moving everything you own is genuinely overwhelming, and landlords know this. They are counting on the panic to make you either leave voluntarily, which saves them the cost of actually going through the legal eviction process, or to not respond to the notice correctly, which allows them to get a default eviction judgment against you without ever having to prove their case in court. A wrongful eviction response filing stops that entire playbook cold. In every state, a tenant who has been served with an eviction notice has the legal right to respond formally in writing within a specific deadline. That response, filed with the appropriate housing court, forces the landlord to actually appear before a judge and prove that the eviction is legally justified. It costs between $0 and $50 to file in most jurisdictions. And the act of filing it alone frequently causes landlords to reconsider, because going through a formal eviction hearing takes time, costs money, requires documentation they may not actually have, and does not always go the way landlords expect when a tenant shows up with a paper trail. For renters over 60, this filing is particularly powerful, because judges in housing courts are increasingly aware of retaliatory eviction patterns targeting older long-term tenants. If you have been in your unit for 7 years, paid on time, and your landlord suddenly decides to evict you over a minor technical violation 6 months after he raised your rent and you complained about it, a judge is going to want to hear that timeline, but only if you show up. And you can only show up if you filed the response that entitled you to be there. The deadline for filing this response varies by state, but is often between 5 and 10 business days from the date you receive the eviction notice. That is not a lot of time, which means you need to know this process before you ever receive a notice, not after. Go to your state's court website and search Eviction Response Filing Tenant. Find the form, understand the deadline. Put the process in a folder somewhere so that if you ever need it, you are not trying to figure it out in a panic at 9 o'clock at night. That is document 3. Document number 4, the renter's benefit verification and assignment letter. Okay, I will be honest. This one has the least exciting name of the 5. I know, I did not name it. But what it does is genuinely important for anyone over 60 on a fixed income, and I would argue it is the most underutilized protective document in the entire renter toolkit, so stay with me here. Here's the situation this document addresses. You are on Social Security, or a pension, or both. Your income is fixed, predictable, and arrives on the same date every month like clockwork. You know exactly how much is coming in. Your landlord knows your rent is due on the 1st. For most months, everything works fine, but then something happens. A medical bill, a car repair, an unexpected expense that lands in the same week as rent, and suddenly you are looking at a shortfall. This happens to millions of renters over 60 every single year, and it is one of the leading triggers for eviction proceedings against older tenants. The renter's benefit verification and assignment letter does 2 things. First, it formally documents your income sources, their amounts, and their payment schedules in a format that your landlord, a housing court, or a mediator can verify independently. This matters more than you think. When a landlord is deciding whether to work with a tenant on a payment arrangement versus filing immediately for eviction, the single biggest factor is confidence that the tenant has reliable income coming. A formal verified document showing that $1,847 in Social Security arrives on the 3rd of every month is infinitely more persuasive than you saying, "I get Social Security." One is a conversation, the other is a document, and in housing disputes, documents win. Second, and this is the part most people don't know about, in many states this letter can be structured as a formal assignment document that directs a specific portion of an incoming benefit payment to your landlord as part of an agreed repayment arrangement. When this is done correctly, through the appropriate housing mediation or court process, it creates a legal record of a mutually agreed resolution that in most cases halts eviction proceedings while the arrangement is in effect. Landlords generally prefer a documented payment plan with a reliable income source over the time and expense of a formal eviction. The document gives them the confidence to accept that arrangement. Without it, you are asking them to take your word for it. And unfortunately, in a business relationship where money is involved, your word alone is rarely enough. Contact your local Social Security office or your pension administrator and request a formal benefit verification letter. It is free. It is typically processed within a few days. Keep it current. Update it annually. And if you ever find yourself in a conversation with a landlord about a payment difficulty, have that document ready before the conversation happens, not after. That is document 4. Document number 5, the local senior renter tax and assistance exemption application. I saved this one for last because it is the one with the most immediate and measurable financial impact for most renters over 60. And it is also the one with the most absurdly unnecessary barriers to accessing it, which makes it both the most valuable and the most frustrating document on this entire list. Here's the situation. In virtually every state in America, there are programs that provide financial assistance to low and moderate income renters over a certain age. Property tax rebates for renters, rent assistance supplements, utility assistance programs tied to housing costs, emergency rental assistance funds. Some of these programs are federally funded through SHUD, some are state funded, some are administered at the county level, and the income thresholds for many of them are higher than most fixed income retirees assume. You do not have to be in financial crisis to qualify. You just have to meet the criteria and apply. And this is where it gets genuinely frustrating because the gap between the people who qualify for these programs and the people who actually use them is enormous. HUD data consistently shows that a substantial percentage of eligible older renters are not enrolled in assistance programs they qualify for. The reason is almost always the same when you survey those households. They did not know the program existed, they assumed they would not qualify, or they started the application and found it confusing and gave up. Every single one of those reasons is an information problem, not an eligibility problem, not a financial problem, an information problem. The application for most of these programs is between 2 and 4 pages. Many of them can be completed online. The required documentation is usually straightforward: proof of age, proof of income, proof of current rental address. The assistance you receive in return can range from a few $100s annually to several $1,000s, depending on your state, your income, and the specific program. In New York, the SCREE program, which stands for Senior Citizen Rent Increase Exemption, and yes, I understand that acronym is doing a lot of heavy lifting, can freeze your rent at its current level for as long as you remain eligible. In Illinois, the Senior Citizens and Disabled Persons Property Tax Relief Program can provide a direct grant of up to $700 annually. In California, the Housing is Key program has provided billions in rental assistance since its launch. These are real programs with real money attached to them, and they are dramatically underutilized by the people they were specifically created to serve. Go to your state's Department of Aging website this week, search senior renter assistance programs, make a list of every program you might qualify for, then call your local area agency on aging and ask them to help you apply. That phone call costs nothing. The application takes an afternoon, and the financial impact can be felt every single month for years. There is no reason not to do this, none. And if you have been renting for years and have never applied for any of these programs, I want you to genuinely think about how much money has left your fixed income that did not have to. That math is uncomfortable, but it is also motivating, because starting today, that changes. Here is your complete checklist. 5 documents. 1 afternoon. 1. File a written habitability notice for any unresolved maintenance issue in your unit. Certified mail. Keep the return receipt. Start the legal clock. 2. Research your state's security deposit dispute process. Write down the deadline. Put it somewhere you will not lose it. 3. Find your state's eviction response filing form right now, before you ever need it. Know the deadline. Keep the form accessible. 4. Request a benefit verification letter from Social Security or your pension administrator. Keep it current. Have it ready before any difficult conversation with your landlord happens. 5. Go to your state's Department of Aging website and apply for every senior renter assistance program you qualify for. Call your local area agency on aging if you need help with the applications. None of this requires a lawyer. None of it requires money you don't have. It requires treating 5 pieces of paper as non-negotiable instead of optional. The gap between the renter who keeps their housing stable and the one who loses everything in a crisis is not luck. It is not money. It is the checklist, and now you have it.